Welcome everyone. My name is Parth. I'm from Economic Laws Practice. Welcome to this DPDP Compliance Countdown webinar, which we are organizing along with IDfy. Before I proceed, let me introduce the distinguished panelists which we have today. So let me first start with Sarika Gandhi. Sarika is Regional Legal Counsel for Lufthansa Group. I mean, whatever I say about these distinguished panelists will be inadequate, but I'm doing my best. She is also a certified mediator and Secretary General from Madhyam International Council for Conflict Resolution. Sarika has worked for more than 20 years with Lufthansa Group in different roles. And currently, she is leading the legal department as Regional Legal Counsel. She advises on data protection laws. She also has experience across aviation law, corporate law, consumer protection law, anti-money laundering law, competition law, and other areas of work as part of her work at Lufthansa. I also have Mr. Bappa Roy from DCB Bank. Mr. Bappa Roy, again, is a veteran, comes with over 35 years of experience. Bappa, please pardon me if I'm disclosing your age. He has worked more than 35 years in BFSI sector, has worked with ANJ previously, Standard Chartered Bank. He joined DCB in 2019 as head of products and has now fully moved, perhaps effective tomorrow, as a data protection officer role at DCB Bank. He has been also done work in wealth management, branch distribution, and digital transformation. Of course, brings a lot of experience on data protection law. I also have Pooja Deshpande from IDfy. Pooja is a lawyer and IAPP-certified, previously expert. IDfy, as many of you know, is a platform for providing technical solutions on data privacy, amongst other things. I'll hand it over to Pooja, who will be moderating today's session. We have roughly around 1 hour for the session, in which I think 45 minutes there will be discussion among the panelists, and we'll have a Q&A from attendees in last 15 minutes. Whatever questions you may have, you can post those in the chat box, and someone from our team will pick those questions to the respective panelists. So welcome you all. I'm handing it over to you, Pooja, please.
Thank you so much. And Parth, you didn't introduce yourself while introducing all of us. We would love to hear about you as well and ELP a little bit in short.
So I did a brief. So my name is Parth Jha. I work with Economic Laws Practice. As some of you would know, ELP is a law firm based across 8 cities in India. We offer services to clients in a variety of areas, including data privacy law. I work with my colleagues here in data protection area. Along with that, I also do a bit of competition law and international trade law. I have been in profession for over 17 years now. I'll hand over to Pooja now.
Thank you. Thank you so much. Good evening, everybody. Thank you for making time today. I know it's the end of the year, end of the quarter. So we really appreciate all of you taking this 1 hour out, and we will try to make it worth your while. And I'm sure that the audience that we have today with us is going to give you a lot of practical insights into how is it that your next year would look like or should look like with the DPDP compliance deadline for May of 2027. And as privacy professionals who are going to set the stage for data privacy in the country, right? I think this seminar or this discussion will hold you in good stead. So without further ado, I'll just jump into our very first question. And this question is to you, Parth, and kind of setting the context, right? It's a law. Fundamentally, of all the operational and technical challenges that are coming in, fundamentally it is a law, and you need to kind of comply with the law, right? So how do you see this compliance kind of getting operationalized? And given that we now only have about 14 months, right? So how should a professional sitting today who has not really thought about his compliance journey, how do they kind of go about it? And specifically, how do they balance the very nuanced requirements of, say, explicit consent, right, for processing personal data, vis-a-vis the purpose limitations and the data minimization requirements coming in? So my question, very short, very point blank to you is, how do you balance the compliance with the law without paralyzing the business operations? Because we all know that data is required to kind of operate in the digital space.
Thanks, Pooja. And I think any answer is going to be, it's difficult to answer it with precision because, of course, the data protection law will have some inroads into business, right? Because the whole purpose of data protection law is to protect privacy of individuals, which means utilization of data is no more going to be unregulated as it was prior to DPDP Act coming into force. So will it create some sort of hindrances in business? Answer is yes. But at the same time, businesses should understand that this is a law which everybody needs to comply. If you are a compliant business, which means you do have a competitive advantage over others, because which means your businesses will not be facing any regulatory scrutiny from the regulators. So compliance is something which you can actually use. It is not a hindrance, so to say. Basically, the law is going to, if you comply well, and if you comply the way law requires you to do, then it's a competitive advantage over your competitors who are not compliant. That's point number one. So therefore, look at the law as not as a hindrance, but perhaps look at it as any other law which you have been complying with. This is one another law which you must need to comply with. My second point is, of course, the law itself is very cumbersome, and absent any any guidance, which we don't have right now and will not have it, businesses should look at law conservatively, which means that they should interpret law in a manner that is data principle centric. So what is a free consent? How your notice should look like? What is a legitimate use? Business should take a conservative view on this and try and do as much compliance as they can. Compliance cannot be just tokenism. They need to comply in the letter and spirit of the law. So the letter of the law may not be clear at times because, of course, we don't have guidance right now. It will evolve over a period of time through interpretations. But that's where I think they need to take sound legal advice and, apply the law that is more data principle centric. By no means I mean to say they need to interpret it absurdly and make businesses impossible to function. No, that's not the intention. But within the realm of the law, it's possible to do business fairly and at the same time also respect, data principles rights. So my second point is to do it conservatively. The third point, quickly, and what they should be doing in 14 months of time. So 14-month time is there. Whether this time will be shortened, extended, nobody knows. And this is the time when they should utilize it for compliance. And if they do the compliance journey with prudence, it is not going to hinder their business activities. Absent that prudence, it is going to impact their business. So 14 months time is exactly for that purpose. There is a full journey for data compliance which they need to do. I'm not going into details of that. I think some of those may come during the conversation today, but I'll pause here. Thank you.
Great, thank you so much. So if I were to take away a couple of points is, first of all, good, so get it right the first time. So spend time in looking at how you are complying with the law. Make sure that you are giving enough and more thought towards the letter and the spirit of compliance. And also this will prevent any future scrutiny. So if you get it right the first time, you will be much better when it comes to any further regulatory scrutiny, or even if that scrutiny comes, the pain will be that much more mitigated because you would have processes and documents in place. But more importantly, it will be a competitive advantage because your energies will not be spent in responding to a scrutiny, but in focusing on your own business, right? Then it'll just take its own course and you will be able to respond without it becoming a business continuity kind of a scenario. And also, like, because you've done it beyond just a tick box, you are in a much better position in case somebody decides to probe in depth. So I think that's beautiful segue into the next question that I had in mind, which is to both Sarika and Bappa, that as DPOs, right? How are you triaging the implementation roadmap, right? Bappa, you're one of the first. The bank, DCB Bank, was one of the first to kind of appoint a full-fledged DPO. Sarika, you have been with a European company with GDPR compliances now, moving into the second half of the decade, in which 6 years are down and then further going on further. So as people on the ground, how did you look at your implementation roadmap? How did you have those tough conversations with your business when you put in controls that didn't allow for unfettered data collection, or which required specific consent before data was collected and processed? So maybe first Sarika, ladies first, and then Bappa, if you could come in, please.
Thank you, Pooja. Thank you for this question, which is very relevant, I would say, because I work for a group which has been following GDPR from 2018 onwards. But if I say we have been following GDPR, I would say the people in the sales or marketing, they only know what is GDPR. They really didn't have, because it was India, so they did not have any expatriate data to take care of in that sense, like how they have to now implement DPDP for Indian passengers of ours. So this, what you're saying, I face it every day. Some telling me, no, we don't have capacity to look into all these laws. You are the person who can take care of the laws. What you will tell us, we'll do. We can't tell you what we are doing. And there are other people who come and say, sorry, we have had hundreds of trainings on GDPR. We have been following GDPR. What's the new thing that DPDP is telling you? I don't think DPDP Indian law can be much more stringent than GDPR. They don't even want to listen how this act is different than GDPR and what areas even the commercial people will need to look into. So, I mean, when I say marketing, they're definitely aware that if they are collecting the data for sending invites and all, they cannot share it with third parties. They cannot share it for any other purpose. This they are aware of after knowing GDPR also. But now when I tell them, if you have taken consent for one of your events, A event, then you cannot use it for B event if the concept is completely different. Don't even say that 2026 consent can be used for A event in 2027. No, that's not how the DPDP works.
Correct.
Which is very, very difficult for them to understand. So what we have done is that we have taken in nominees from each department and each company of Lufthansa Group who will be responsible to implement DPDP along with me in their areas. I thought that was the best way to do. And the next step is, I think, to train everybody for DPDP. Unless they are being trained on the intricacies of DPDP, they will not understand what the law tells us to do. It's not only Sarika who is telling them to do this. It's the law which mandates that certain things have to be done.
Right.
Hope I've been able to answer your question, Pooja.
Absolutely. No, brilliant point there. And especially I liked how you made it so simple about the time based consents and the proportionality of the use of consent also. So it's basically a consent has to be specific, like event A versus event B, and also has to be time bound. Just because you took it once doesn't mean you can continue using it again. Brilliant. Thank you for that. And I also understand that training is a very important part, and it is not just one team or one. It has to percolate across the ecosystem. Bappa, if you have any, would love to hear your thoughts on this.
So, Sarika's covered. Can you hear me?
Yes, we can hear you, but unfortunately, your video is not visible to us.
Okay, I thought it is. I'm not going to mess with the system now.
Sure. No
Let me do with my talking, and then I'll see if I can switch on the video. Okay. Couple of things. One is for banks. and for many other companies, data privacy has always been there. Okay, so it's not new. We are particularly anal about data and how to keep the data private. So there will be, so it's not a journey where we are starting from the first block. Okay, so our regulations, existing regulations also mandate, not expect, mandate the banks to protect data. But there will be nuances which are different, particularly the rights of the data principle in terms of in terms of erasing data, in terms of modifying data, in terms of reviewing data. So those are new areas which, of course, have to be addressed. But it's not a journey that we are starting from block one. We are already in the journey. It's that the finishing line has moved, and and we have to strive further to reach the finishing line. The second is, I think it's very important for the organization when it comes to implementing something. What is the message from the top? So from so we were very clear that we would have a dedicated data protection officer, and we, even before the rules were published in November, we didn't know when the rules would be published, but we appointed a data protection officer, that is me, sometime in September last year. And the messaging from the top, that's from the board and as well as the managing director, is that there is no compromise on DPDPA. Okay, so clearly that sets the tone, because if that's what the management is talking about, the rank and file will know that they have to fall in line. So there have been difficult conversations, and there have been challenges. The refrain is that, okay, we have to do it differently. Please guide us on how we can do it differently. I think the most important thing for us to first understand is, where do we stand? What is the gap that we have with the Act as we speak? Gap assessment is important because, surprisingly, when you do a gap assessment, one would realize that quite a few of the boxes are already ticked, and it's only a few boxes which need attention, and we could focus our efforts and our time only on those boxes. So I think an important part of this journey is to understand where an organization stands in light of the requirements of DPDPA, and then frame a plan or a roadmap to implement those areas which are still uncovered. So three things. One is, it's the message from the top. Second, have a plan in place. And third, take things bite-sized. While you say it's 14 months and lots to be done, yeah, it's lots to be done, but you need to take things bite-sized. Kill one bird at a time instead of going for the entire bush.
Right. Perfect.
Hello? Yeah, did you get that? I mean,
yes, we did. So what I did take away from this conversation was that, first of all, there are different nuances that the law has introduced, but data privacy has been around, especially in the BFSI, in the banking space, for a long time, and almost built in by default into the processes that are there. And it is only about identifying these processes and these synergies, and then looking at what is the incremental delta, right, that one needs to look at, and then bridge that. The other thing that you very rightly said is executive buy-in. So a word from the board, or ensuring that that the very senior most decision makers in the organization are sensitized, are made aware of the law, and then they are kind of made aware of the importance and the mind. And once the message comes from there, then automatically it kind of flows down across all the other mid and lower ranks of the organization. And again, like you rightly said, well begun is half done. So bite-sized activities, don't get bogged down or overwhelmed by all the nuances. Start with breaking down what you already have, what you need to do, understanding what needs to be done, and then go about bite-sized approach to kind of take it from one step at a time, one day at a time, and soon towards the end of it, you will have had a good chunk of your readiness already in place, right? Brilliant. Thank you so much for that. This brings us to the next set of ideas that we would like to discuss, primarily to do around data guidance, data governance, and data discovery. And here again, I would like to ask Bappa to come in with his views, because like you rightly mentioned, privacy is not a new concept for banks. So banks already knew how to kind of identify, how to secure important information, sensitive information, and now the fact that personal data is also being debated as whether it is sensitive, not sensitive, should it be awarded the same amount of security as other sensitive, traditionally sensitive information such as OVD documents and so on and so forth. So would love to hear from you about how should DPOs specifically approach their data governance and data discovery programs, and within this strict implementation window that we have, how much time should they earmark to get into this data discovery exercise when the volume of data can run into petabytes, right? So how much of time, how much of effort should they budget for this kind of exercise? And the next thing is whether that is enough to then go ahead and demonstrate compliance. So say, for example, if I've done data discovery, does that exercise in itself amount to a good compliance practice?
Okay, first of all, can you see me now? I have enabled my camera, but I'm not sure whether you can see me.
Yes, we can see you now. Thank you.
Okay, good. Okay, so data discovery, if you ask me the timelines, if we take our own experience, we actually started the data discovery journey well before the rules came into play. Okay, and there are several good tools available in the market to understand to help organizations do data discovery. We obviously have invested in some of these. Uh, Data discovery is ongoing. I mean, there will be, of course, ebbs and tides, but data discovery is ongoing. It's important to identify capabilities which are available today, which could assist an organization in doing data discovery, and there are several which are, and they're very effective. So we started on data discovery as early as last year, even before the rules came into play, because, as I said, that banks have always been particularly focused on data privacy. So it's a journey which we've begun even before the DPDP Act. I think gap assessment is important. I think one should at least set aside, because that's a big task. And I take what Sarika also mentioned, that we also have appointed spokes in every function and business, and they work with my team, and they work with our teams to identify essentially where does the data come from, where does it sit, who processes it, where does it go, and where does it finally rest. And in this entire journey, what is the gap that we see with what is required in the law. So I think that takes time, because the larger the organization, the longer it will take. If I were to use our own experience, we have almost taken a full quarter in doing the gap assessment, because resources are also limited, so we can't do all departments or many departments at one time. But the good thing is that once you do a first few departments and businesses, one gets a hang of it, and therefore the exercise takes much less time with incremental businesses and departments. So I think most important is to start the gap assessment if it hasn't already started, because that takes time. And once you do the gap assessment, putting guardrails in place shouldn't take time, because you know where the leakages are, or the possible leakages could be. I'm not saying where they are, where the possible leakages could be, and then you put the right processes in place.
Got it. Perfect. Parth, would you have any thoughts on how to expedite a gap assessment process? Because if I were to kind of do a reverse calculation or a back calculation, if somebody were to start a gap assessment, say from the 1st or the 6th of March, 6th of April, the first working day of the new financial year, and then spend 3 months or say spend some time in doing gap assessments, that effectively leaves them with only about 6 more calendar months to do a full technology integration and looking at other activities as well. So how, as somebody who does undertake gap assessments and advise clients on gap assessments, how do you think we could expedite this? Sorry, I'm going a little off script, but I think it would be really interesting to know your thoughts on this.
Yeah, I mean, there are no ways. I mean, the only way to expedite gap assessment is to start doing it yesterday, right? Please understand, and this is for everyone, audience here. If your data flow mapping and gap assessments have gaps, then your compliance will also have gaps. So you can expedite it, and you may have a gap assessment report again for satisfaction that you have a tick box, so you do have a gap assessment. But if your gap assessment itself has gaps, you'll be never able to comply. So I think it's very important that gap assessment is done very carefully, because that's kind of a North Star for you in terms of how you want to be DPDP law compliant, because that's the North Star which will tell you where all the gaps are. And if that is not adequately done and not done properly, you will be actually blindsided in terms of how you're going to comply with that. So to answer your question, Pooja, how to expedite it is that you should start it now. As you hear this conversation, you should immediately take steps for gap assessment, whether you're doing in-house, whether you're doing it through external counsel advice or assistance. You should do it with utmost priority and urgency, because we simply don't know at this point in time whether there is going to be any extension or not. Number one. Number two, you don't know if the government is going to advance the deadlines, right? So therefore, yeah, that's my answer. I don't know if it helps anyone, but there's no other way to do it.
Understood. Sarika, any inputs from your end on how should one start?
Yes, Pooja, I mean, lots have been said by Bappa and Parth already and very relevant. I can just say what we are doing at Lufthansa Group. As I said, we have already nominated people. We have had a full day meeting with all nominees, from different parts of India to in Delhi. I guided them, I trained them. We discussed many issues, what they also came up with, where they are collecting data, what they are doing, or where are the areas they feel the risky ones. And as I said, we were already following GDPR. So we need to do one gap analysis between the GDPR and DPDP. So I have given a list to all the nominees about the 10, 12 differences that I could see there. Then for the gap analysis, what we have done is we have prepared a data mapping template, which has been given to all companies, all departments. Every personal data that has been collected, processed, I have at least more than 20, 30 columns in that. They have to put everything there, including the cross-border transfer, including if there is any processor, any sub-processor. So in the next meeting, we are going to discuss about these processes. I don't think I am at the level where Mr. Bappa is with the banks. We are lagging much behind, but I think we took it easy because of the GDPR also. But I feel we are on the right track. I'm having day-to-day calls with all the nominees. I'm guiding them how to fill up this, what all is required. And our next step is that we are preparing questions which are coming through all these analyses and all these discussions, which will be then sent to external legal company for complete guidance. Where we are lagging, what more we need to do. So I think even if 5 questions come from each group companies, we'll have at least 40, 50 questions.
Right.
And the answers to them will help everybody.
Absolutely. No, thank you so much. And what I'm hearing is knowing what needs to be implemented is absolutely important in making sure that the implementation is done right the first time. But one thing that I would also like to kind of, and maybe I'm the minority here when I say this, but this is a new law, right? So some of the gaps are absolutely evident, because there was no requirement to do those activities in the past, right? So for example, displaying notice in 22 languages, right? There was no previous compliance requirement to do that, right? So we know that this is an obvious gap. So I would also urge, and maybe I'm coming out of my moderator role over here, but as a fellow privacy practitioner, I would also urge organizations to start thinking about what are those obvious gaps, right, that you already have, which were, and there are gaps not because there is some deficiency in process, but because it was never required in the past to be done, right? So look at those gaps and start thinking about how you're going to remediate those ones. So you don't need somebody else to come and tell you how to remediate those one gaps. But yes, for the more tricky, the more nuanced ones, please make sure that you are understanding the problem before you start looking for a solution, right? With that, coming back to my next question, and this is to both the lawyers in the room. We all know that now a data processor can only be onboarded after a written contract, right? So a data processor in effect is somebody who processes data on your behalf, and that by that definition would include all the data process, all the vendors or all the third parties that any organization of scale would have in thousands. So how do you kind of look at tackling this very specific issue on contract management, on third party risk management? Because there are two things. One is that the third party, any breaches suffered by the third party, the data fiduciary becomes responsible for it, and also the data processor is required to delete data post processing, right? So how are you as fiduciaries looking at tackling this problem? And once I have the lawyer's answer, I would go to Bappa and see what is the tactical advantage that he can help us identify after working with the bank for so long. So maybe Parth, you could go first, and then maybe Sarika.
Thanks, Pooja. I think, of course, Sarika will give more practical insights on this. But just to take your question, I think it's very important, first of all, to have an open conversation with counterparties, right? Because, again, there's no straitjacket formula for this. Depending upon who your counterparty is, conversations are going to have different levels, right? So think about a small and medium-sized vendor doesn't know anything about perhaps data protection law, has not been exposed to this, been little advocacy around it, then one has to say that why this change is going to be brought in, right? So I think it's very important to have, first of all, an open, good faith conversation that the contracts need to be relooked at. Number two is that the comfort has to be given that the commercials of the contract are not changing substantially, right? So every contract has an underlying commercial objective that is not changing. But because there is a regulatory change, and most contracts will have a clause which will trigger a revision because of regulatory change, typically you have that, right? So there will be some changes which will be required for data compliance, right? And it's good for both parties. So it's not something which any party, and even the counterparty, the data processor so-called, and it could be reverse also, they need to worry about. Because one thing which every party in a contract would like to have is certainty and clarity, right? You don't want to be in a situation where you simply are taken for surprise. Something happens, a data breach has happened, some monetary losses has been suffered, and suddenly liabilities are being passed on and you're discussing your indemnity clause suddenly, right? You don't want to be in that situation. So you have to have clarity from both sides. So it's good to have that conversation, actually. In some cases, it may result into negotiations which may be a bit cumbersome, like I said, depending upon the nature of the contract itself. As you rightly put out, that ultimately, as far as the DPDP Act is concerned, it's data fiduciary which bears all the responsibility, right? And therefore, given the nature of the contract, in some cases, if there is a breach by data processor, obviously data fiduciary will be in, it will have a good case to argue that I can't take all the liability, somebody else has to now take the liability and fill in those shoes. So there will be some renegotiation on some of the liability clauses, I think indemnity clauses. I think all those need to be navigated carefully. The bottom line is that none of the parties should be taken or should be taking obligations or, for that matter, risk more than that is required. And so long that good faith clarity is between the parties, I really don't see why contracts will not be relooked at and done properly. I think it should be possible. But happy to hear Sarika's thoughts on this as well.
Sarika?
Yeah, thank you. So I think Parth has elaborated a lot and guided us on the right way. If I talk about my organization, when it comes to the DPAs or the data processing agreements, I do not see much of a problem. Why? Because any new contract that we want to enter, somehow or the other, one of the expatriate data is involved. I mean, I'm only talking about the contracts which have the processing of personal data. In that case, uh, the GDPR talks of SCC, standard contractual clauses. There are 4 types of SCCs. So we have always had a conversation, even in our RFP stage, with our vendors that we need to have this contract. We may or may not have it later because some of the vendors really don't want to get into it. It's a German legislation. Why are you forcing us into it? And they find a way out how not to have the personal data of the expatriate. So, but we have had these conversations at the stage of RFP with 90% of our vendors, the big vendors I'm talking about. Smaller ones is still, we'll see. We plan to send, I have educated all the spokes that the next step is that we will, once our data mapping is ready, then we'll go and with which of the vendors we need to have a DPA. It will be taken in as an annex to the commercial agreement. And we plan to send, once our data mapping is ready, because DPA will take a lot of time, but we plan to send a notice to all the processors that under DPDPA, we are going to come back with a contract which will be signed and it will form a part of the commercial agreement. It will be annexed to it. So at least all the stakeholders are ready. Their mindset is ready. What are the next steps? And we just have to implement. I mean, we are going step by step. Yes.
Understood. So what I heard is basically one thing that, if I may say, it's very smart, to be honest, is first identifying which are the key high sensitive vendors that you need to go after, who are the ones that you need to first secure through these contracts, and then kind of look at the medium and the long tail. So that's a very efficient approach also, to be honest, because we all know that contracts take long time for negotiations. And to Parth's point, yes, both parties need certainty, right? And it is that establishment of that trust that basically takes the time before the contract is signed, and so on and so forth. So wonderful insight there. Identify which are your key sensitive vendors, and then kind of look at tackling those contracts first rather than looking at the whole cohort. Bappa, any insights or strategies that you would like to share on how do we manage vendors per se and vendor privacy risks?
I think the agreement is the lesser of the uh, problem because our agreements anyway have privacy clauses, and it's just that we would need to embellish them with some additional terms and conditions or clauses as required. I think it's the physicality of ensuring that it gets done with all the vendors. Banks do have a fair number of vendors across the network, so it's just the physicality of just getting it done. But I don't see uh, the contracts being much of a challenge. I agree with Sarika. I think the more important thing would be how do we implement the additional nuances or the requirements of the DPDP Act. So a vendor could be a debit card switch provider. That vendor is well educated, well aware, literate, and and they themselves would be conversant about their rights and their obligations under the act. So that won't be a challenge. But to get the smaller vendors and to make them understand what is required of them in the new regime, that is that's where that's where the real challenge is. Uh, so that has to start quickly enough. Not just the contractual obligations. That can be managed, but to make them understand what additional safeguards are required from their end. Uh, for example, data purging, uh, periodic audits. So those are the things which I think we should focus on, and that's what really is what we have started on. It's still a long journey, but I think that's what we really need to focus on as far as vendors are concerned.
Perfect. Perfect. Thank you for actually bringing those very important points out. One is data purging and the audits, because what I am hearing is whilst contracts are the starting point, organizations that do not follow through with good purging mechanisms or policies and auditing whether what was written in the contract is actually being followed or not, right, they land up in a much hotter soup as compared to those who kind of did the due diligence across the life cycle of the vendor, because not only are these controls mitigatory, but they're also sometimes deterrent and preventative, right? You can detect early signs of a potential breach or a weak link or a vulnerability that is creeping into your value chain, and then address that proactively rather than waiting for a breach to be suffered. So brilliant insight there. Thank you so much. If I were to just basically summarize this section, the primary is look at who your key vendors are. Look at ensuring that they have the right templates so that the right amount of certainty, like Parth mentioned, is brought into those templates. And then also look at doing audits and following through with purge mechanisms and due diligence, so that whatever was mentioned in the contract is being followed across by the vendors. The next big operational beast to tackle, if I may call it that, is the data principal rights requests, right? Because if history is to be repeated in that sense, what happened with GDPR or what happened with right to information also, the minute the law becomes applicable, there is going to be this set of individuals who would be very interested in knowing or in raising those access requests with organizations in knowing what data is held, how it is being processed, so on and so forth. So to both Sarika and Bappa, if there are any thoughts on how do we tackle these kind of requests, either historically if you've done that, or what is your game plan, or what is your advice on preparedness to when the floodgates open, especially with DPARs?
Sarika, ladies first, as Pooja said.
Okay. So, Pooja, so far, I have not seen any data principal requests directly from the data principals. I'll have to make a policy with respect to these kind of requests, how these will be handled, who will be the stakeholders involved in it. And because the law is very clear now, you know, that the person has to be satisfied, otherwise he goes to the next channels of grievance and all those things.
Yeah.
So this policy still has to be made. Once our mapping is ready, we'll do this also. So far, the requests which were coming were from authorities. We used to get a lot of requests from, let's say, police. If they are investigating in a case, they would come to us. Okay, this person traveled on so and so date. Please provide us the data. Or sometimes from enforcement agencies also. But because we were following GDPR, we have never provided any personal data to anybody. So we always used to give what is called international letter of request, which says that please, if you have to have this data, personal data from us, please come via the requisite embassy. Then only we can entertain the request. That's the international process, and we have been following it up. Luckily, never ever received anything from embassy. I don't know why. Even though, I mean, with police, sometimes if they call me personally, I do help them because on one-to-one basis, but on record, nothing.
Understood. Very interesting. So it's actually a very tactical insight to especially professionals who are working with multinational companies. And in my previous interactions also, I've heard that we've received a request which requires us to disclose data of international customers, people who may be of Indian origin but are not currently in India, NRIs and so on and so forth. So how should we kind of go about that? So I think it's a very nice input there, that you always kind of seek guidance from the embassy, because that's the authority that is governing them. Very interesting input over there. Bappa, would love to hear your thoughts as well on how do you plan to handle DPRs.
Sorry, Pooja, you were saying something. Sorry.
I'm saying I would love to hear your thoughts on how do you plan to handle the barrage of access requests or the data principal rights requests or deletion requests that are going to come in.
So I think that is I think one very major part of the implementation process, because what you mentioned is actually shrouded under consent management. So in the sense that the principal has to be given a notice of the notice for the data that we are seeking and the purpose for it, has to have the right to review the data from time to time, erase the data, modify the data. And that actually is something which is, if you ask me, in gap assessment, that's a real gap, because while we take consent, the entire ecosystem of providing the principal ways and means to review, renew, or erase the consent given earlier, and to ensure that and from on the part of the organization to ensure that that is implemented is something very new. And I think that's and consent management, which is closely linked to the data principals' rights, is actually due for rollout by November. So it's not actually a May 2027 deadline. I think consent management, and Parth can correct me if I'm wrong, is a November 2026 deadline. So I like to say, one of the things I like to point out is that this is a new act, and organizations have to use the ecosystem. I think just doing it on one's own self may not be the right solution. So there are providers, there are service providers, there are law firms who will help you with helping you with contractual obligations. There are consultants who help you with, laying out a roadmap for DPDP implementations. There are technology partners who can help you with, platforms for consent management. So I think we got to understand how do we manage consent. Would it be done in-house, or would we take the help of a provider, and then have an implementation plan? But I think this is a very important part of the entire journey, because this kicks in much earlier than the rest of the act.
Very interesting that you've brought it in here, because yes, as soon as the consent managers are live, once their licenses are issued and once they become live, data principals will be free to raise requests through those managers, and then you will be required to respond to it. And I think the timeline for response is also the outer timeline is about 90 days, right, in which you need to respond to a data principal request. So very, very pertinent there, and would love to kind of talk a little bit more about how we plan to kind of meet this deadline and be prepared with it. But I'm also cognizant of the time. We are already at 4:50. So whilst our conversations have been quite free-flowing, I didn't realize how the time went. And we also have a few questions in the chat, right? So with all of your approval or guidance, I would like to kind of go through the questions quickly first, so that our audience feels that their questions are answered, and then if we still have some time, we'll go back to a few questions, if that's all right with everybody.
Fine, absolutely.
Yeah, perfect. All right. So the first question, and I'm not going in any particular order, but just seeing as they're coming in. Okay, what an organization should do who is already GDPR compliant? What are the extra compliances we need to do from DPDP perspective? I think Sarika already answered this question pretty well. So I'll just quickly summarize in the interest of time. You need to look at what are the gaps, what are the specific DPDP requirements, as, for example, notice in 22 languages, doing DPIAs, which are more periodic in nature rather than trigger-based, looking at your data processor agreements and taking in the DPDP specific specific clauses. Also look at children's data, how that is processed. So all of these nuances which are very DPDP centric. So kind of have a look at that and then take it forward. One thing which we absolutely know is that GDPR compliance doesn't automatically equate to DPDP compliance. You need to kind of have your documentation ready to support that. The next question is, will MNCs be considered as SDF? Parth, if you want to kind of take a stab at it. SDF, significant data fiduciaries.
Yeah, I mean, the origin of your ownership is not something which is relevant for SDF. SDF, essentially, as you know from the law, will be determined based on the volume and sensitivity of data which you process, right? Unfortunately, we don't know as of yet which companies will be SDF or will qualify as SDF. You could be a domestic company, no MNC at all. You could be SDF. You can be MNC, and you can become SDF depending upon the nature. I mean, the idea is that if you are processing a huge amount of volume of data is very huge, and the data which you process is sensitive, although law doesn't define what is sensitive, but they will come out with a criteria, perhaps you will qualify as SDF. Some examples which seems obvious based on media reporting is, like, say, big tech companies, social media intermediaries could qualify as SDF. But who all will qualify as SDF, we'll have to wait and watch.
Okay, perfect. Thank you so much for that. I hope the person has asked the question anonymously, so I hope you've got the answer. If not, you can always reach out to us and we'll help you kind of get the answers. The next question is consent manager requirement mandatory or optional and not applicable again to MNCs? So, I mean, it's open to the floor if any of you want to kind of attempt at answering this question.
I will love to hear Sarika's and Bappa's thoughts as well. Well, I mean, our understanding
I'll defer to the lawyers. On this one, I'll defer to the lawyers.
I knew that, Bappa. So, well, I don't think that it's mandatory from the law. I mean, again, it's sad that some of these some of these very basic concepts could have been clarified well in the law. And perhaps my sense is that these are the questions which industry is asking. And therefore, my sense is that there could be some clarification on this timeline. But if we just read the letter of the law, it doesn't look like it's mandatory that everybody must have a consent manager in place. If companies would like to comply with the law without resorting to help from a consent manager, perhaps they can do it.
Yeah. So I think
but in practice, it's good to have a consent management platform because, you know, the whole automated process on managing consent, withdrawal, notice, retention, erasure, all of that becomes a lot easier if you are doing it through a consent manager platform, which have specific tools and applications and software which can which will reduce your cost and increase efficiency.
Perfect. So and I'd love to pick that small distinction here. One is a consent manager and one is a consent management solution, right? Or a management platform that you talked about. And you know, I know why you're smiling, because you and I have had multiple conversations on this. So very quickly, a manager is an independent third party which will be licensed by the Data Protection Board to act as a customer facing entity, right? So if you are a data principal who wants to raise a request on a fiduciary, then you can take the route of either going via consent manager, or you can reach out to the bank or to the travel or to any of your other companies directly. A consent management solution is what an organization chooses to use in order to manage the consents of its customers. So when I am, say, for example, opening a direct account with the DCB Bank, or I'm booking a ticket on Lufthansa, if I'm going directly to these organizations, then they are collecting my personal data. And at that time, I would expect them to tell me what they're holding, how they're processing that data, what are they going to do with it, so on and so forth, and whether they have explicit consent to do all of these activities. And therefore, they would want a solution of their own so that they can provide these services to their customers. So that slight difference, which actually is a monumental shift in liabilities in that sense, is a consent manager is an external party. A management solution is in effect a platform that you can ingest and then demonstrate compliance with the law. All right. Next question is to do with how does a normal manufacturing private limited company come under the purview of DPDPA? How should they comply with this Privacy Act?
Okay, I'm going to take it. So, again, as Pooja explained at the very beginning of this session, that this is a sector agnostic law. If you are processing personal data which is in digital form, the Act applies to you with only very few limited exceptions. And those exceptions are set out in the law, they're very narrow. So it doesn't matter if you're a manufacturing company. Well, the difference is that if you're a manufacturing company, and we are actually advising a lot of manufacturing company in different sectors, industry sectors, your volume of data which you may be collecting could be low because most of your transactions could be B2B, it could be B2C also, depending upon what kind of manufacturing you're doing. To the extent you are processing digital personal data, the law will apply to you, right? You have employees, the law will apply to you because you are in possession of personal data of individuals and you are processing it. So the short answer to the question is that if you are a manufacturing company and if you think that your data collection exercise is already very low, compliance is easier for you. So please get together your act and comply with the law as soon as you can.
Correct. Perfect. Thank you. Thank you so much. I will just take last two questions very quickly. Beyond policy and process, how are organizations actually verifying the data principles understand and experience their rights correctly on the ground? And the second question was very interesting. If you take consent from, say, your vendors and your third parties and your employees today in April of 2026 in compliance with DPDPA, then do you need to seek consent again or intimate them again once the law becomes applicable in 27? So these are the two questions that we would like the panelists to answer. The first one is on how are organizations verifying the data principles understand or maybe awareness amongst data principles. And the second one is, if I take consent now, do I need to take consent again a year later?
Is that to me, Pooja?
It's open to the
Bappa.
panelists. So
Go ahead, Bappa.
Bappa, Sarika, and
So I'll take the first one of it because it's actually I would think that the data principles understanding of their rights, I think, is also something which is vested with the data fiduciaries. So uh, it is, I mean, if you ask a customer today, a bank customer, that you are a data principal and you know what your rights are, he or she wouldn't know. So I think it rests with the data fiduciaries that how well we educate our data principals about their rights. Uh, there could be always there could always be a question that is it the responsibility, is this laid out in the act? In some ways it is, because to implement the act properly and in a compliant manner, both parties should have a clear understanding of their rights and responsibilities. And unless the data principal is aware of their own rights and responsibilities, the fiduciary won't be able to implement the act. So I think a lot depends. It's a very good question. So, like over the years, banks have been entrusted with the task of educating customers about cyber crimes, how to prevent cyber crimes, how to prevent fraudulent actions on their accounts. This will also be a responsibility which will rest with the fiduciary, that they do that through various media they do educate the data principal about their own rights and their rights and their responsibilities as well. If you read the act, the data principal also has certain responsibilities. So
yeah,
not only their rights but also their responsibilities as a data principal.
yeah, absolutely, absolutely. Sarika, any thoughts on creating awareness on taking consent again?
No, I completely agree with what Bappa has said. As a data fiduciary, it is our responsibility also to make the data principal aware about their rights and what are our duties, what are we obliged to do. when I would make a grievance policy, I think these will be the considerations that one has. The whole consent mechanism also. If we always say the consent starts from the notice stage. What have you notified to the data principal? What is being collected? About so the talking about their rights starts from there. But as we mature with having our documentation, our policy is ready, I think the clarity would come from there. Yes.
Yeah, perfect. Thank you so much. And I think with that, we are on dot.
So I don't think we answered the first question. Maybe Parth can take a stab at it. That if
Sure.
we take a consent today, do we need to take consent in 2027? So Parth, maybe you could take a stab at that.
Yeah.
Thanks, Bappa. Yeah, so I think the answer to that question is that anything which you're doing prior to the commencement of the Act, an Act, let's say, commences in May 2027, everything which you have done now, even if you think that you have complied with the new law as it exists today, let's say you have given notice, your notices in so many languages, plain, clear, unambiguous, all the things which you have done, good things, all of this will become legacy data, historical data, once the Act comes into force. And for that, what you'll have to do is an exercise called Section 5.2 exercise. You got to give them a notice once again, saying that we collected this data and we are using it for these purposes, and you've got to do certain other things given in Section 5.2 about rights, etc., and wait for them to react. If nobody reacts, nobody withdraws, you continue with that data processing as you have been doing unless somebody withdraws. Any new data which you collect after the commencement of the Act, you must comply with a fresh notice. I hope that answers your query.
All right, perfect. I do not see any further activity on the chat, but in case the attendees want to continue the conversation or ask questions, then the LinkedIn profiles of all of us have been posted. So please feel free. Parth, you're on mute. Sorry if you're saying something.
No. Please continue. Please continue.
Yeah. So I was saying, so all of our LinkedIn profiles are pinned on the chat. So please feel free to reach out to us, and would love to kind of hear your views on how you felt this webinar, or there are any other questions that you would want us to answer. We are planning a few other series with ELP. So if you have any thoughts on this, would love to hear that, so that we can make it a much more interesting and a much more interactive conversation going forward. You've been a lovely audience. Thank you so much, and all the best for the year-end closure. And let's make DPDP compliance our motto for the next coming financial year. Right? Thank you so much. Thank you so much for the
Thank you, everyone.
for their
Thank
time.
you, everybody.
Really
Thank
appreciate
you.
it.
Bye-bye. Bye.